Let's turn now to Marcus in Birmingham. Good evening to you, Marcus. How are you this evening?
I'm doing okay. How about yourself?
We are well,
Hey,
and we are
Marcus.
grateful for your call. If you will, go right ahead with your question.
Yes, my question is, I was on workers' comp for almost 3 years, and I had to take a fitness test to go back to work, and I wasn't able to pass the test. And so in return, I got fired, and workers comp stopped my benefit. And now I'm left out on the limb. What is my option?
Wow.
How much time do we have? Marcus, your situation, unfortunately, is very, very common. And what happens is there's only a certain number of weeks, depending on the type of injury that you have, there's a certain number of weeks assigned to your type of injury that the law permits for you to receive temporary total disability, frequently called work comp checks. They either come weekly or every other week. Then at some point, your authorized treating work comp doctor says, you're about as good as you're going to get from a medical standpoint. You've leveled off in your care. There's not anything I can do medically to get you improved to where you are. So that's called maximum medical improvement. And that is it's a legal term that's applied to work comp situations with doctors in this kind of scenario. So the way that the law works, in theory, your work comp checks will stop at MMI because it's the hope you then go back into the workforce, whether it's with the current employer or a new employer, depending on your situation. You took what's called a functional capacities evaluation, an FCE. That's typically 2 to 4 hours at a physical therapist's office, and they're measuring what you can and cannot do, pushing and pulling and standing and lifting and a whole series that at the end of that time period, they measure what you can and can't do, and it's supposed to be extrapolated over a 40-hour week. It's not a perfect test, but it's the one that we have. The employer can then determine, based on the results of that test, if you have limitations. For example, if you can't lift more than 10 pounds, or you have to alternate sitting and standing, you shouldn't do repetitive, whatever your particular situation is, the employer does not have to automatically bring you back into employment. If you're not in a union, Marcus, I know that you underwent the FCE, and that's the tool that the employer is going to look at to see whether or not they can bring you back to work. If there are limitations and they can't accommodate that, they can lawfully terminate your employment. And frequently that's what companies do, because we're an at-will employment state, which means the employer doesn't have to hold a job for you unless there's an FMLA issue, which is a federal issue that we won't talk about tonight. They can relieve you of your employment, and that also leaves you without workers' comp checks at the time. So sometimes you may be in that weird period of time where you don't have income. But now would be the time, hopefully, for you to be able to settle your case or go try your case in court, depending on your situation. And you do have a limited period of time of basically 2 years from either the day of the accident, or if you're getting those work comp checks that Marcus said he's been getting for the last 3 years, it's 2 years from when those checks stop. You either have to settle your case or you have to have your case filed in court.
Bernard, on the heels of Marcus's call, what a great call. Thank you, Marcus, for that. Talk to us about when it is unlawful for an employer to terminate you as a result of a work comp injury. And also talk about when an injured employee needs to reach out to you and start getting legal help. When is that? When is the time for that? And also, what does it cost them to do that?
It doesn't cost anything to call a lawyer. The lawyer and the potential client can have a conversation about how the logistics work. Alabama workers' comp, when you hire a lawyer, you have to sign a contract, and it's a contingency fee of 15%. It's set by law statutorily. If you're a potential client of our firm or of Kirby's firm, I want you to call as soon as practical, not down the road when other things have happened and you're thinking that now it's an emergency, I need a lawyer. The quicker you get in with the lawyer, the better, because you can be, the whole goal is to lower your stress. You lower that stress by providing answers, and that's what we do for our clients.
That's good.
Yeah.
Marcus, we're going to give out Bernard's number at the end of the show, so stay with us just in case you want to talk further with him. Thank you for calling.